As always, it's great to have you all back on CoinLady channel. Our next topic will be XRP. My first point is that the SEC's crackdown on cryptocurrencies means that even Ripple naysayers have no choice but to support XRP. Their fate will be tied to that of XRP. They were staring disaster in the face for a full 3 years before they finally saw it coming. Gary is now also staking for stablecoins. Ripple is out there staking its claim to the cryptocurrency world. People still don't get it, but I think we'll finally have some clarity around cryptocurrencies if Ripple wins this case, which will trigger the next run. However, crypto would be set back by at least a year, if not more, if Ripple were to lose. Every cryptocurrency on the market will be impacted by this case more so than most people realize. If Joe Katz is correct, then XRP will most likely not reach $5, $8, $9, etc. The point here is the buyback, though. Since I've been challenged on this a lot, I think it's important to explain why I believe this way. For what reason are you remaining silent? How come you're not on board with this? Now I'll go over it with you one more time. So, Ripple's Chief Technology Officer David Schwartz has tweeted his thoughts on the re-emergence of the XRP buyback proposal that was first discussed in 2021. After being reintroduced by Vigil Capital CEO Jimmy Varley, the proposal has sparked heated debate on Twitter once more. When government debt increases everywhere and all banks that participate in TERSO 222 switch to using XRP for international transactions, this theory predicts that XRP will become the world's reserve currency. As a result, governments around the world would have to purchase substantial quantities of XRP. For some context, let's back up a bit. By that time, the global financial system will be in disarray, and an immediate need for on-demand liquidity will arise for XRP as the world experiences a global liquidity crisis. In exchange for your XRP USD, what would you receive as payment? No way, no how. At that point, the value of the US dollar would be close to zero. Then speculation arose that both the SDR and XRP might have a gold backing. The XRP cryptocurrency does not require any backing. The value of this new medium of exchange will be comparable to that of gold and silver. And if XRP is being repurchased, there should be no reason why XLM shouldn't be as well. Considering the massive monetary transfers that will occur between these two cryptocurrencies. I won't say a buyback never happens, however, by the time it does, the world may be in complete anarchy, and I'd rather keep you safe from that than anything else. When the current financial system fails, panic will ensue. Let me just say this to you now. Because I believe there will be a transition phase in which you may have to barter or something similar, you should be holding some physical gold and silver. You have no idea how long it can take to set up a new financial system and get things running again after a major collapse. I'd like to believe that the new system will be up and running in parallel with the old one before the old one completely collapses. There will be both digital currency and traditional currency available. However, given the current global trend, that outcome seems unlikely. You and I don't have to agree on everything. Don't give up hope for a buyback just yet. But never give anyone your cryptographic keys. And I'll explain why in a minute. Who will be responsible for keeping the contract if things get so bad that martial law is declared? Do we know if the courts will be functioning normally? Will there be a lull before order and safety are reinstated in the country? Don't sell your crypto just yet. Perhaps anything is possible. There is no value in the US dollar at all. Imagine this. Crypto is the only form of payment accepted. You have signed your cryptocurrency over to Vail Capital as a custodian, so you no longer have access to it. Because neither the phone system nor the internet are working at the moment, nobody is available to take your call. Keep in mind that the truly shocking and unexpected event is predicted to occur. In the end, all I care about is making sure you're secure. I could come on here and say that I support the buyback 100%, and I'd get 100,000 views in a day. Probably. Of course, if I did that, I wouldn't be telling the truth. No. Should I tell you what I think? No. I'll explain the factors that make you feel secure about holding onto your crypto so you can profit from it in the future. I'd like to help you in that way. If you're so convinced of the merit of what we're saying, perhaps you could part with some of your XRP. Feel free to proceed. However, I would not recommend doing so because I cannot predict where we will be when things finally come together. I anticipate that once the new system is operational, central banks will assign a value to XRP. Gold's value comes from the same factors that give other commodities their monetary worth. And I think that's exactly what will occur. And I still think XRP will reach high prices in the future, and I think it will be a high-price stable coin as well. It's time to discuss this because it happened today and Forbes removed the article. This pits Ripple against SEC. Report from a Forbes senior writer: you will be viewing a motion to release Hinman documents. I intend to demonstrate at a later time. As such, Layton's lawyer Kyle Sasser filed a motion yesterday asking for permission to petition the court for access to the drafts of William Hammond's controversial speech from 2018. Attorneys for Layton have argued against a recent SEC motion to redact portions of Hyman's speech. You may recall that on December 22, 2022, the SEC requested confidentiality for certain papers relating to the Hinman speech document it submitted in support of its summary judgment motion. Some of Hyman's controversial speech documents were cited by Ripple in its opposition, and the SEC asked for their confidentiality. So she's taking legal action to get the word out. Rosalind Layton asks why SEC has a different policy for Ripple and Ethereum. Moreover, what transpired? Because of some unknown issue, Forbes removed the entire article. Maybe somebody put them in touch with Gary Gensler and he worked his magic. Here, though, is Forbes's since removed article. The SEC's differential treatment of Ripple and Ether. In that case, let's examine this together. It's difficult to ignore the disparate application of security laws to the Ethereum Foundation and companies like Ripple, despite the fact that regulators aren't supposed to pick winners and losers in different markets. They must be law-abiding citizens. After more than 2 years under the microscope, a judge in the Southern District of New York is debating whether to unseal the Hinman speech documents as part of the Securities and Exchange Commission case against Ripple Labs. What we're all hoping for. Please share the contents of those files with us. The documents make reference to a talk given by William Hinman, the then Director of Corporate Finance at SEC, in 2018. In the absence of clear regulatory guidance, this talk represents the best public instruction for crypto stakeholders to avoid enforcement action. And we all know he was making a mint. It was only after declaring the native token of the Ethereum blockchain, Ether, to be exempt from the securities laws that it was given the green light to operate. The SEC then filed a lawsuit against Ethereum Ripple, another similar project, demanding multi-billion-dollar fines for a product that appeared to be identical to Hinman's definition of Ether. This discrepancy worries me as a scholar of regulatory issues. See, she gets it. It's not lost on her that something isn't adding up. Why did Ethereum get a free pass? Hinman may have had a financial interest in a group that favored Ether over rival coins like XRP, which would create a conflict of interests. Separately, the government watchdog group Empowered Oversight filed a lawsuit against the SEC in an effort to obtain documents proving that Hinman received millions of dollars in retirement payments from his former law firm Simpson, Thacher and Bartlett, and that STB joined an alliance dedicated to emphasis on Ethereum only. Even so, SEC cautioned Hinman that such differences might surface. Even if we already know that Ethereum advocates influenced Hinman's speech, unsealing the speech documents could shed light on the matter. Clearly, while Hinman himself starts the speech by saying that it only reflects his view, not the SEC's. The opening could reveal whether or not the SEC has an opinion on the matter. Before making such statements public, it is common practice to get the okay from the agency's legal department. Findings like these might bolster the defense's claim that the SEC failed to provide fair notice of the SEC. The organization's own crypto policy stance was unclear or uncertain. So it stands to reason that financiers and creatives might be as well. This case represents an important test of the Carolian concept of regulation by enforcement. The SEC's approach to crypto asset regulation has been met with controversy due to enforcement issues. Actually, it hasn't stopped happening even now. This is the root cause of the chaos in the crypto industry. There are no rules in place, so no one knows what to do. There are important legal questions at stake, including whether the pursuit of enforcements against innovation technologies for lack of compliance and other purported harms is a legitimate use of taxpayer resources, and whether the CSC's delineation of policy is clear and forthright. The battle of motions to seal or unseal is a common debate in federal regulatory litigation, unless Congress acts to prevent it. Thomas Barton Vartanian, a former general counsel at the banking regulator, elaborates. Although openness safeguards information sharing in the administrative process, the courts are frequently asked to weigh in on whether or not the privilege is being abused. It is possible for courts to review the relevant evidence behind closed doors, where it will be seen only by the judge who will ultimately decide the appropriate scope of the protection. Due to the sensitive nature of the information contained within, legal counsel for the SEC has moved to seal the documents in question. The SEC was regularly updated on the SEC's thoughts and stances on problematic programming issues. These documents should not be made public because doing so would hinder agency officials' ability to engage in open and candid debate and collaboration. According to the court filing, therefore, we are already familiar with the contents of those papers. We have proof that Hinman was receiving compensation. It seems like Ethereum got off easy. Therefore, there is no reason to delay making this information public. Reason being that Gary, as far as I'm aware, is still keen on preserving Ethereum. I still believe they are collaborating on something. The Securities and Exchange Commission, SEC website does provide a list of Freedom of Information Act exemptions, including those related to national security, trade secrets, and individual privacy. Attorney-client privilege, which protects communications between lawyers and their clients during the planning and preparation stages of a case, does not apply to the court's rulings on the speech and writings. This necessitates its release to the general populace. The SEC may face an uphill battle in court if it tries to use his remarks as evidence that he provided adequate regulatory guidance in a speech he later made public. Regulatory capture, first described in George Stigler's 1971 seminal work, Theory of Economic Regulation, for which he won the Nobel Prize in Economics, describes the situation in which a regulatory agency favors one actor in response to requests from the firm or industry. Stigler argued that the purpose of regulation is not to safeguard citizens but to benefit businesses. And while we're embroiled in this litigation, I also believe the following to be true. American innovation is being stifled. The world around us is changing rapidly. He mentioned how the SEC was given the authority to cap commissions on mutual fund sales, which would slow the expansion of smaller funds while cutting the commissions paid by larger ones. My own research into the contentious topic of net neutrality, which builds on Stigler's work, reveals a similar trend of established U.S. technology platforms advocating for internet regulation in 50 countries over the past decade in order to block upstart competitors from entering their markets. They're actively stifling innovation in favor of a select few profitable businesses. The very next Google is supposed to be protected by these open internet rules, but in reality they stifle competition and innovation among new services and apps by regulating their prices and the volume of traffic they generate. So Google can count on a lifetime of monopoly. Adopting regulations with narrow, specific goals is necessary when tackling complex issues. Actually, the crypto sector has repeatedly urged Congress to draft legislation to define U.S. regulators' responsibilities. At present, at least 8 different organizations claim authority over crypto assets. For the same reason, Brad never misses a session of Congress. It's been going on for far too long, and he wants them to intervene and put Gary in his place. The writer has no stake in the cryptocurrency market and has no personal gain from this case. She's just looking out for the cryptocurrency community without any vested interest in any of the parties mentioned in the article. But she has no crypto at all. As part of her research on regulatory policy, she is conducting this study at no cost to herself. She was not financially compensated for her involvement in a motion asking the SEC to disclose information about this case. Someone like that exists, and they're doing uncompensated work in the crypto space. That's how strongly she thinks the SEC is tainted, and how deeply she thinks corruption has been entwined with the Ripple case from the beginning. And then, naturally, Forbes pulls the article, and I think Gary probably called up some buddies over there and crushed us. The general public should not know about this. However, you can see for yourself what is taking place. We require rules and laws. These days, when starting out, crypto businesses know what they're doing. Companies like LBR, which is still in its garage phase, should never have to defend itself against an SEC lawsuit. If Gary continues to classify every crypto asset as a security, however, it will. For that reason, this Ripple case must be addressed. As a result, progress will be made across the entire crypto industry. Cryptocurrency adoption will increase as a result. Cryptocurrency will see a flood of institutional funding. If that happens, business will join you. Lending institutions will join us. In due time, of course. However, at this point I must conclude this video. To everyone who has been tuning in, I appreciate it. Many thanks to everyone who has watched my videos. Please like and subscribe my channel if you enjoyed my video. See you in the next video. Bye.